Good afternoon, everyone, and welcome to this month's Residential Conveyancing Forum. I hope you're all well. We've had a really successful four-part series on the conveyancing process with Ian Quayle, and I hope as many of you as possible have been enjoying them. Now that they're finished, we did promise to answer any of the questions that you had, so that is now baked into Ian's presentation, so he will go over that. And as always, please reach out to me if you need to talk about anything title insurance related, and I will get back to you. All my details are on the slides later. But Ian, thank you very much, and take it away.
Thanks very much. Thank you, Freddie, and good afternoon, everyone. Yeah, a massive thank you to Stewart Title, as ever, for sponsoring these events. I've had the fortune of working with Freddie and Robert recently with regard to conferences, etc. And it's really lovely to listen to what they've got to say about product, about their expertise, about the assistance that they're willing to provide the profession. So as Freddie quite rightly mentions, if you have any issues with regard to title indemnity insurance, if you want to chat about a policy, if you want some hand-holding with regard to the Solutions online policy, Freddie, Robert and the team are all there to help you with regard to all of those issues. As ever, this forum is recorded. We're able and happy to discuss any topics or burning issues that you have. But as usual, there are some topics that I would like to look at. And as Freddie quite rightly mentions, there were some issues and topics that were explored or which were generated from the series of 4 webinars that we've just completed. So we will be looking at those before we finish today. So a massive thank you to Freddie for sort of sitting in the background, looking after tech and all that goes with it. Freddie's details are on the slide there. So anything in connection with Stewart Title product or any issues with regard to title indemnity insurance, do contact Fred. And as far as issues today are concerned or topics for future forums such as this, either let Freddie know or let me know, and we'll gladly sort of incorporate questions, queries or topics in connection with future events. I always mention useful websites, and again, I was just speaking at a conference this afternoon or early this morning too about leasehold transactions. Do have a look at the Leasehold Advisory Service website if you're not familiar with it. Boatloads and boatloads of information there that's really useful for you as busy practitioners. All the other sites, again, you'll be aware of and familiar with, so I won't trouble you or burden you by discussing what they are. So let's start today by having a look at some of the questions that the series of 4 webinars that we've done with Stewart Title have generated. So first question 1 here. What remedies are available to a buyer where a seller pulls out, given the buyer would lose its deposit if the other way round? So very interesting question about remedies and about deposits. So let's start with the basics. As far as the deposit is concerned, if a seller breaches contract by refusing or being unable to complete, the buyer can ask for its deposit back. Remember, the deposit is being held by the seller as stakeholder, meaning that the deposit will be sitting in the seller's solicitor's client account or will have been used on a dependent purchase. Either way, it will be possible to trace that deposit and, if need be, obtain the return of the deposit. Now, 2 or 3 things flow on from that. Firstly, just because a party is an innocent party and the other party is defaulting does not mean that the innocent party is automatically entitled to the deposit. All things being equal, they are. However, have a look at Section 49 of the Law of Property Act 1925, which enables the court or gives the court a discretion as to what is to happen to the deposit. So let's assume that we have a situation where a seller has defaulted, but the default of the seller is through no fault of the seller. And let's assume the buyer is able to buy a similar property and the price that's paid is significantly less than the buyer was going to pay the defaulting seller. Let's also assume that the buyer has incurred little or no expenses or costs as a consequence of seller default. Then in those circumstances, there is a chance that what a court will say is that the buyer is not necessarily entitled to all its deposit back. The court might order that some of the deposit be returned, might order that none of the deposit be returned on the basis that the buyer has not sustained loss in circumstances where the buyer has been able to buy a property at a significantly cheaper price than he would contracted to purchase the property from the defaulting seller. So if you've got a situation where the market is in decline, the property market is in decline, our buyer might manage to negotiate a bargain, meaning that he's paying a lot less than he would have been paying the defaulting seller, in which case there's no guarantee we get all our deposit back. Again, just to make sure that we've got clarity, the general position is that the buyer would be entitled to the deposit back in full. But as I say, Section 49, I think it's Section 49(2) of the Law Property Act 1925 gives the court a discretion as to what is to happen to the deposit. The second question, flowing on from our series of 4 webinars, Ian mentioned requiring wet ink signatures on the contract. Is DocuSign suitable as it's now when signing deeds for it to provide the required PG82 certificate with the AP1? Well, as far as the methods of signature are concerned, DocuSign could be used. The only point there would be that it would be as a courtesy disclosing to the other side the method of signature and making sure that as far as the firm that's acting for the client that's signing using some form of electronic format or DocuSign is comfortable that the client is aware of the document they're signing and the significance and consequence of signing it. So I think you need to be more robust with regard to tightening up what you're advising the client upon with regard to the contract, explaining to the client that the signature is nonetheless a signature that could, on exchange of contract, create a legally binding contract on the part of the signatory with all the legal obligations and implications arising. The next question that we've got, if you're advised of a likely delay in decompletion in good time, should you consider the possibility of a variation to the contract to agree a later completion date? Well, this is a really interesting point. Okay, if there's a likely delay in completion in good time, it is possible for the parties to agree a delayed completion. But that of itself would require the creation of a new contract, because you can't vary a contract that is already between the parties. So we exchange contracts today on the 15th of October, and we want to vary completion tomorrow on the 16th of October, as the contract stipulates the contract will be completed, say, on the 30th of October, and we want now to put the date for completion back to, say, the 5th of November. We can't vary the original contract. We can create a new contract referring to the old contract, complying with Section 2, subsection 1 of the Law of Property Miscellaneous Provisions Act 1989, that then creates a new contract with a new revised date for completion. The next question, Ian, can you explain what you said about the interest exceeding the 10% deposit and courts not enforcing it, please? Of course I can. This is a very interesting point about penalties. The idea of a deposit is that it's consideration for a contract for the sale or purchase of land. And there are decisions of the courts that say where the deposit payable is over and above 10%, then it is a penalty. In other words, it is a penalty because it is, in the event of default, retained by the other contracting party. So there's case law that says in that context the deposit is a penalty, meaning that the deposit is void and unenforceable. There's also a case from memory where the court said the entire contract is enforceable because of the fact that the deposit was a penalty. So there are cases on both of those points. But thank you very much for that question. If we go to the next slide, we've got some observations. So So we'll just have a look at that and we'll discuss it. Some selling conveyancers draft a TR1 and arrange for the seller to sign this. Most often it doesn't include the buyer's correct details, and despite the buyer sending one and then agreeing to use the buyer's version, they hand over the incorrect version on completion. 2 parts not acceptable. TA13 sending a copy TA1 to the buyer before completion, but these are not being complied with. So how do we stop this practice? It requires, and it's a great observation, it requires one, in the TA13, the buyer indicating that it will not accept a TR1 that has been drafted and executed by a seller. That the TR1 that the buyer is insisting on is the TR1 produced by the buyer, and perhaps we could specify it is executed by the buyer or buyers before execution by the seller. But you're quite right, this is a problem. Okay, and the reason it's a problem is a lot of conveyancers are trying to sort of short circuit the conveyancing process, get the job done more swiftly. And the problem with that is that what is being done, although having benefits with regard to streamlining or speeding up the process, is not compliant with the conveyancing protocol or current or conveyancing practice as required by documentation. And therefore we've got to ensure that what we're saying in the TA13 is consistent with what we're doing or what we're requiring in practice. Now, Zara makes a good point about the use of electronic TR1. So can I put my first question to the room? How many people are using electronic TR1s? And Zara, when we talk about electronic TR1, we're talking about an electronic signature too, are we? So again, answer question. Yeah. Lots of people using them. Okay, Lynn, Zara, anybody else? Have we had any pushback from anyone on the other side? And what's our client's reaction to the use of electronic TR1? Anybody? What are we finding? And on the issue of TR1s, yeah, I think clients can struggle. That would be a point I made. The other point with regard to TR1s, and I was just discussing that this morning. Yeah, don't trust. Yeah. Hi, Dorothy. Yeah, Dorothy, you could do that. And yeah, so there's a bit of pushback from solicitors. Okay, interesting. I think with the idea of electronic exchanges of contract and that new guidance from the Law Society, I think more and more firms are going to be happier with electronic signatures on electronic documents. It has to come. Interestingly, if you go on the City of London Law Society's website and look at the Land Law Subcommittee, they were the first to sort of embrace the use of electronic signatures. But there's another point I wanted to make about TR1s, which I was discussing this morning. Where you're acting for co-owners, it's essential that co-owners sign the TR1 as an acknowledgement of their agreement as to the form of co-ownership. So again, I would always want a buyer client to sign a TR1 where we're buying as co-owners, and I'd always want to draw to my buyer's attention what box 1 provides for, and to confirm that it's consistent with what our clients wanted to do relating to co-ownership. So I'm just interested, going back to the electronic TR1, anyone sort of vehemently against what the team are saying this afternoon? And Dorothy, yeah, the idea of the seller sends, but Dorothy, do you find people doing that? Sending the draft transfer in Word format to the buyer? I thought some did, Zara. I thought some lenders were, particularly on remortgages, allowing electronic signatures on mortgage deeds. It's rare, is it? Okay, yeah. Yeah. But going back to Dorothy's point, anyone adopted that as a strategy? So sending it as a draft to the other side when you're acting for a seller. Yeah. It's not mentioned on the handbook at all, is it? I don't think. Zara. Right. Hi, Dorothy. I send out draft transfer words so some of them just insist on their own form when they could just amend the word. Yeah, well, that's a good point, Dorothy. I mean, the whole idea of the conveyancing protocol is collaboration, isn't it? Yeah. Okay, Annabelle, thanks for that. That's great. Lovely. Okay, so what about that point I'm making about co-owners then? Do you think I'm being pedantic in saying to the buyer clients, look, you're signing this, have a look at box 10, realize that what we're saying is you're buying as joint tenants in law and in equity or tenants in common on whatever division of the beneficial interest or whatever. Do you think I'm being too pedantic, or do you think it's important to do that? The reason I suggest it is there's a couple of cases where a buyer didn't sign the transfer and the TR1 box 10 was inconsistent with what the parties agreed. Yeah, it's separate. Yeah. Yeah, Dorothy, buyer can still sign the version of the counterpart transfer, but yeah, it could do that, of course, Dorothy. But does that not just complicate things a bit? And what about this joint ownership declaration that Zara mentions? Zara, where did you get that from? Yeah, hi Zara. Yeah, fire away, my friend. Don't know if we can allow Zara to speak. Don't have control. Go on, Zara. Hopefully you can talk. Just trying to get you. Oh, the mic's on
Oh,
mute. I can't.
hiya.
Oh, hiya,
Yeah.
hello, Zara. Yes.
Yeah,
Yeah. Go
I
on.
think it stems from a case a few years ago
Mhm.
where the husband and wife were buying, and then the wife said she hadn't authorized the transaction. So I always get them to sign a separate joint
Yeah.
ownership declaration, one to confirm that they've had the advice on joint ownership and that they understand what they need,
Yeah.
and then it's got the options as to what they want, and if it's a declaration of trust, then I know to go off and get a declaration of trust, and
Yeah.
that's front loaded so
Yeah.
that they've got time to think about it.
Yeah, good point. All right, thanks for that, Zara. Yeah, I think I agree with it. Lovely, thank you. Dorothy, we have a form we sent the client for them to advise joint, or yeah, I think that's sort of an information sheet when you're scoping the retainer at the start of the transaction, isn't it, Dorothy? But again, I just think that when they're asking the client to sign the transfer, it's just a useful reminder. And again, just another way of cross-checking that the clients are happy with what was agreed earlier on in the transaction. That's why I would adopt that strategy, I think. Yeah. Okay. Now then, I just want to change layout if I can for a minute because I've got people on the screen here. Right. Zara, mine is a flowchart to assist with decision making. Well, that's a good idea too. I think the important point there, Zara, with co-owners is that as far as the flowchart is concerned, getting information from the client, then explaining choice. And I think the other key point, Zara, is be really wary with co-ownership where the client is wanting to do something that's not logical and not consistent with what they should be doing as far as the law is concerned. In other words, putting it simply, clients who are making equal contributions with regard to deposit, equal contributions with regard to mortgage repayments, etc., but then saying we want to own as tenants in common, 80% her favour, 20% in mine. That sort of thing worries me. Right. Haley, hi Haley. We have a form and a guide sent out to client care. Then we send the property report, which includes a confirmation of the instruction. Transfer deed goes with the property report. So you've got all bases covered there, haven't you, Haley? That's fine. Okay, fine, good. Now then, let's just have a look at what I was wanting to do. If I can just find my slides again, and I can't at the moment. Bear with me. Here we go. Right, yeah. Let's have a look at this next observation. Land registry taking a little long to deal with application. 2 purchases that were complete before the notice I applied to protect the contract. Yeah, I mean, that is a point, isn't it? As far as notice applications are concerned, they are taking a long time. And therefore, you say to yourself, what's the point in protecting the exchange of contract by notice? Of course, the point there is that you are protecting an interest in land, and there is an issue about the application as opposed to the noting on the title. There was a case, wasn't there, about the fact that when is the interest in land protected, when the application is submitted, or when the notice is actually placed on the title. There was a case on that a while ago. But yeah, and I agree that the protection of the exchange by notice can hold up registration of the purchase. I agree with that. So yes, it's something worth bearing in mind. Thank you for that. That's a good point. Okay, let's just push on if I can. Right. Yeah. All right, Dorothy, thank you. When you put in an AP1, if you have put in a UN1, you can apply to cancel at the same time, so that that doesn't sort of queer the pitch, does it? Good point. Thank you, Dorothy, for that. Okay, right. I want to talk about some of the things I've mentioned on the slide. Remember, today is open forum. We can talk about anything and anything that you're encountering. I just want to talk about one or two of these cases. The first thing I want to talk about is this case of Bloomfield against Monia Road Limited. Has anyone seen that? I'm writing an article in the next edition of Property Law UK, and it's a really interesting case because what the First Tier Tribunal has said is to practitioners, don't rely on the government guidance on the Building Safety Act. It's not legislation. It's not necessarily enforceable. And therefore, they've really shot across the bow of all conveyancers, basically saying the government guidance has to be treated with extreme caution. The case in connection with the government guidance concerned the height of a higher risk building, and the tribunal's finding was that a roof garden was a story for the purposes of determining a higher risk building. And despite the fact that their finding was contrary to government guidance, their attitude was, well, government guidance is that created by government departments, not the courts, and therefore has to be treated with extreme caution. That's a case that I think will have real consequences for anyone doing BSA related work. There's another point that flows on from that, and that is this. As far as the First Tier Tribunal is concerned, it seems more and more to be aware of just how poor the Building Safety Act and regulations are, and therefore goes back to first principles, namely, what's the purpose of the Building Safety Act? 1, to protect leaseholders from service charge costs relating to remediation work for relevant defects. 2, to make sure that those that are responsible for work that requires remediation pay for the work that now requires remediating. So I think there's those 2 points are important points relating to the Building Safety Act. The next thing I want to talk about is the revised TA6 form. And again, I'll come back to that point, Megan, because it's a good one. With regard to the revised TA6 form, again, on my travels, and I've spoken at about 4 or 5 conferences in the last fortnight, the vast majority of firms are not touching the revised TA6. But what they're saying is bigger firms are using the revised TA6, so we're encountering them with regard to contract packs. And what I'm doing is looking at this and saying, well, all right, if you're acting for a buyer in these circumstances, what do you do? And I think my conclusions are as follows. 1, I would advise a buyer, given recent case law, of just how possible it is to bring an action for misrepresentation. Number 2, I think the next point to note is that the questions that are now contained in the revised TA6 are significantly wider than in the old TA6, and a wider ranging question warrants a wider ranging answer. Thirdly, a seller answering questions in the TA forms is obliged to undertake reasonable investigations before answering the questions. So there's a whole raft of different things I think apply where we're getting a revised TA6 or a revised TA7 from a seller's solicitor when acting for a buyer. Right, let's just look at some of these questions that we've got. First of all, Megan, hi Megan. So much government departs from legal position. Yeah, EPC guidance. What we need is a better guidance, and I don't think we're going to get it, Megan, to be honest with you. I think I've put an email out to government about this to say, are you going to revise your guidance in the light of the Blomfield case? Because you're quite right, the government guidance does depart. And the problem is that where you've got such a complex piece of legislation as the Building Safety Act, you're sort of clutching at straws to seek guidance and help. I mentioned to you, have I mentioned before this case of Lena? I can't remember the name of the property, but it was a case of Lena where the first tier tribunal gave guidance as to what to do when acting for a seller and a buyer with regard to landlord certificates, leaseholder deeds of certificate in relevant buildings. Right, so I've answered that one. Zara, could you explain why the Law Society keep pushing the propaganda with the intention that the 5th edition will be used as is? The Law Society, to be honest, Zara, I think the Law Society is far too close to government and pushing messages that the government wants pushing and not thinking about what's in the best interests of their membership and equally what's in the best interests of our clients. So I think that's the problem. Megan, can we put pressure on forms providers to make the old TA6 available online again? Yeah. I think that's a good point, Megan, and certainly we should do that. Zaro may have to ignore. I hear most calls. Yeah, I think they are. I think they are, but I'm not getting any signals or indicators from the Law Society that they're going to push the revised TA6 into the long grass or just abandon it. Don't hear that. And again, with regard to consultation on climate change, the point there is if the Law Society wants to consult on climate change and guidance to conveyances relating to climate change, surely they've got to disclose the draft guidance relating to climate change. If not, it just becomes a mockery, doesn't it? So the Law Society, thanks very much, Hayley. Yeah. Really useful case, isn't it, Hayley? Yeah, that's the one. Hi, Mayumi. Yeah, you're right, Mayumi. Is that the consultation on climate change or is that the consultation on the TA6? I think it's consultation on climate change, isn't it, Dorothy? No, Law Society conference tomorrow. I'm not going. I was invited, but I can't go. I'm speaking at another conference all day, so I can't attend. To be honest, I feel sorry. I feel sorry for the Law Society committee on the basis I think their hands are tied. And I feel sorry for members of the profession because, as I say, we've got a trade union that seems to me isn't on our side at all. At all. You can't just say to people, use this. You can't say to people, oh, well, use it, but we're consulting or we've consulted on reform, etc. Yeah, I think the consultation's over, isn't it? All right, Megan, okay. So have you been told that there are going to be meetings? Told about that or not? Okay, next thing. Well, there's a few things really with regard to HM Land Registry. Number one, our friends at Stewart Title are working on, and I've been asked to sort of assist in connection with the project, an insurance policy in connection with applications for first registration. In other words, you're acting for a client who submitted an application for first registration, and your client now has to sell the house because they're being relocated for work, etc. What do you think about an insurance policy that protects a buyer who is buying a property that's in the course of registration at the land registry? Do you think there's mileage for that as a product until the land registry get their act together or not? Yes, Sarah, I've seen that, but I haven't watched them either. But I don't know. Yeah. Did you, Zara, what was it like? Useful? No, I mean, it's like the Law Society guidance on the Building Safety Act. I just think it doesn't help. Well, Megan, as I say, Stewart Title are working on this. Okay. Right. Yeah, they do, Dorothy. And I mean, the moment the Land Registry get their act together, there's no need for a policy. But I'm not getting consistent information from HMLR that expedition is working. And I'm still, again, this morning, talking to firms that have had applications outstanding 2 years, 3 years, etc. And you're right, Dorothy, in connection with the production of a policy, it gets the Land Registry off the hook, doesn't it? So I just thought I'd mention that. The other thing is, with regard to the Land Registry. All right, yeah, Zara? Yeah. It's a good point. I've got to talk to the Land Registry about projects, Zara, and I mentioned that because, if I may, I'm going to take a photograph of it. I think that's a really interesting point. So I'll just take a picture of that to remind me of what we need to do. Because Land Registry are always asking me about, hey, what should we do next, or what can we do to help? Yes, I agree, Dorothy. There's inconsistency between officers, definitely. Right. Okay, now, next thing, the Land Registry's training platform. Who's seen it? Who uses it? Yeah, I've seen that, Zara. Yeah. Never used it, but have you looked at it, Zara? Has anyone else looked at it? And what's the feedback, Dorothy? Right, okay. Between us, I've been asked by the Land Registry to look at it and do some work with them on the basis that they feel the profession doesn't use it and that it needs tweaking. So this is really interesting. I'll share this. Thank you very much, Zara. Well, yeah. I'm talking to them. We've got a project with them, and we'll see how it goes. Yeah. Okay. Right. Yeah. Right. Okay. Good. Okay. They've sent me data with regard to Land Registry requisitions. Guess what? The major area of requisition from HMLR is. Yeah. Okay, Zara. Good point. Thank you. Yeah, restrictions. Correct, Megan. You're talking of hundreds of thousands of requisitions a year on restrictions, and the complexity of restrictions. Do you think that restrictions are complex? Is not another way of sort of protecting interest in land rather than a restriction? What's everyone's views on restrictions? They are complicated, aren't they? And the terminology and the fact there isn't a definition of disposition in the Land Registration Act. So you have to define what you mean by disposition. I think that's a major problem and a major issue. Yeah. So, yeah. Well, yes, Sue, again, we're back to that old chestnut, aren't we, about inexperienced Land Registry staff. Sometimes you'll get a Land Registry officer telling you something, you know it's wrong. Yeah. Hello, Giuseppe. Yeah, I agree. Yeah, sometimes do. And again, I think that's inexperience, to be honest. I mean, I know they've recruited loads of staff. I know they're trying. All right, Megan. So are they saying you should use a standard form restriction, Megan? Was that what the discussion was about? Yeah, fee increase from December. Yeah, are you telling clients, Zara, and are you sort of quoting now with regard to fees? Yeah, I think the point there, Dorothy, is that the land registry officers sometimes don't have any discretion, do they? And Zara, as a consequence of the land registry charging more, has that given you an opportunity to revisit your fees? And if you're dealing with revised TA6s, revised TA7s, etc., are you charging more for that? Hi, Lisa. Of one where the restriction requires consent who no longer has an interest in the land, the magic can in one restriction, in one X restriction. Trying to get clarity from themselves as to how to do this can be so frustrating. Yeah, one of the things, yeah, Sue, we'll put your microphone on and someone will deal with that for me. While I'm waiting, I just want to, so Sue, we should get your microphone on. Natasha or Freddie, if you can deal with that for me, that would be brilliant, please. Right, well, waiting for Sue. Megan had no form restriction and they tried sure and didn't understand the commercial value of control of a consent. Yeah, okay, I see. So the land registry officer just didn't get what you're trying to do, Megan. Yeah. Yeah, okay. So again, we're trying to get Sue.
Yeah, I'm on now.
Oh, lovely. Hi, Sue. Yeah, good to hear from you.
Hi, you
Go on.
okay, Ian?
Yeah, I'm fine, thank you.
Good,
Yeah,
good.
yeah, go on.
I just wanted to mention while we're on the point of restrictions and something that just got me so frustrated. Like 4 years later, we're still not. We sold a piece of land, or sorry, we sold a property years ago under right to buy.
Yeah.
As you know, I work in a housing association, and I think 4 years later, 5 years later, they're still not registered because the land registry haven't got to grips with a restriction that's on our title that doesn't apply to the area of the estate where this property is.
Right.
The problem that we're having is there is nowhere in the restriction, it just says, you know, not to transfer without so-and-so's certificate, whatever. What it doesn't give you the option of is saying that the restriction does not apply. Some restriction wording says that, doesn't it? Or that it doesn't apply.
Yeah.
But this restriction doesn't apply, but it doesn't give you the option to say it doesn't apply. So it's just, you know, the wording is just really causing a lot of problems at the moment because the land registry won't accept that it doesn't apply without being told it doesn't apply. It's really weird.
That's bizarre. What I always say, you know, is you can ask the land registry to refer it to their legal department. Have you done that?
I haven't.
You can sometimes override the land registry officer and say, can your legal department have a look at it? Because that's nonsensical to me.
Yeah. I mean, it clearly, if you read the document that the restriction refers to, it clearly doesn't cover the part of this huge estate that the property is in. Yeah. So, but of course, the land registry aren't going to be reading documents that contain restrictions. So I'm trying to tell them, and they're just not getting it. Which I'm sure they would if they read the document, but I don't expect them to do that. Right. Oh, okay.
Ask to refer it up. And the other thing, Sue, send me an email, because one of the first things we're doing with the land registry's training department is a webinar on restrictions. So bring that across to me, and we'll use that as a sort of case study, if we may.
Perfect.
And we'll see if we can get that resolved. Yeah, lovely. Thank you.
Okay.
All right. Lovely. Thanks, Sue. Thanks. Good to talk to you. Hannah. Hi, Hannah. Currently get copies of the register plan before even instruction back as a loss lease, just so check for issues as possible. However, now the fees increase, much more of a loss. So no longer. Yeah, well, that's a point, isn't it, Hannah? I mean, I understand, you know, everyone's costs are increasing, aren't they? But the fact that they do increase does mean that this sort of opportunity to download early and have a look at where we're at disappears, doesn't it? Okay. So again, Hannah, what you mentioned there sort of touches on what I was saying about, you know, where we've got a problem with a title. The earlier we can spot the title, spot the problem, the better opportunity to resolve it, rather than, like Sue was saying there, encountering a problem after completion with all the problems that can generate. Right, Dorothy, if party no longer has an interest in the action you've taken, they should be able to proceed with the registration. Yeah, I'd go further, Dorothy, there, and you should be able to disapply the restriction, shouldn't you? Yeah, Megan, then there's a silly request to register restriction rather than parties agreeing the wording. Why else do they agree if they didn't want to register it? Or does not apply as very useful wording for all restrictions? Yeah. And again, Dorothy, hi Dorothy, coaching times that you're making a complaint the correspondence has not been dealt with properly and put to a senior case. Dorothy, that's the sort of school of thought that I have, because the further up the line you get, the more chance you get of what you're asking for, which is often just what the practice guides require, getting achieved, isn't it? Yeah, you can. Practice guide 19. And again, the land registry seem to be encouraging the use of disapplication rather than cancellation and modification, aren't they? Don't know if you've seen that. Okay, great. So yeah, anyone got any issues with regard to email restrictions, ping me an email on it. And as I say, we've got this issue with the land registry, which Stewart Title is sponsoring, by the way, again, which is kind. On the basis of the land registry don't have a budget with regard to training, which is another story for another day. Anyway, okay. Reporting on title. There was a sort of debate on LinkedIn. And sometimes I get a bit disappointed with LinkedIn, to be honest with you. Sometimes I think it's really useful. There'll be snippets or there'll be advice or guidance that I think is really, really useful. And then other times I think, well, I don't really want to know that or why doing it. So I'm falling a little bit out of favor, out of love with LinkedIn, to be honest with you. But there was something on LinkedIn the other day about using interim reports on title, or whether you'd produce a report on title. It was quite interesting because it showed you the sort of spectrum of attitudes, with a number of practitioners saying, we work on the basis of one hit. So we will produce, when due diligence is completed, a report on title that covers off everything. And lots of other firms and contributors on LinkedIn saying, we don't do that. What we do is we produce interim reports. Now, I've always been in the school of the use of interim reports rather than one final report. And if I explain to you my thinking, if I'm producing interim reports, I'm drip feeding clients with information in smaller chunks. And therefore, there's a greater chance that important messages, are being sent to the client. Whereas if I'm sending one massive report on title to the client before I exchange contracts, key messages in that report are more likely to be lost. The opposite side of the fence is, if I produce one report on title, it's only one document for the client to look at. Right, Zara, I had to use a 45 to 60 page report, so if I messed up, they could look at the report and title to see where I messed up. Yeah, that's a different issue, Zara, but I get the point. Yeah, well, that's the point, Megan. Someone mentioned it on LinkedIn, and I thought, yeah, you're right. Why wait to tell the client there's a fundamental problem with regard to the seller's title? Surely I should be reporting that as early as I possibly can, so the client can then say, well, thanks, but no thanks. And so we're not wasting time and wasting cost. So, Megan, I think you're in my school. Zara, I break mine down, report and title report and search report, mortgage, and if necessary, report on LP1. I agree with all that, Zara. What about, would you produce a separate report in connection with the lease? And it's in the report and title itself. Okay. Yeah. And do you provide information? If it was a leasehold transaction, do you provide information to the client at the start of the transaction about leasehold ownership? Really interesting. Sue, yeah. Can you just tell me what the important bits? And what do you do? No, I'm not. I can't do that. Sue, that's the issue there, isn't it? Right, a comparison. Let's just have a look. Go back to this. I have a comparison table on buy leasehold. Yeah, good idea. Yeah. 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 Well done, Mayumi. I agree with that. Again, it's just getting this balance of making sure we're getting key messages across to the client. Going back to that problem that Sue mentioned, where the client is saying, just tell me. Well, all right, if I can get the client in or have a virtual meeting with the client, then fine. But I'm still going to have to confirm what all I've said in the meeting in writing to the client. Because if not, there's a danger that the client says, well, he didn't say that to me. And again, over the years, I've acted for a client who couldn't read. And what we used to do is have to have someone with us making a note of everything that was said on the basis that our insurers were terrified about the potential for claims. Yeah. Yeah. Yeah, a bundle of documents, a good idea, Dorothy. I like that. Yeah, there is. I mean, it's one of the things that worries me, Zara, that, I tell people, have you thought about this? Like today, talking about co-ownership. Have you explained to clients who own as joint tenants in law and in equity the possibility of unilateral severance? Well, again, that's more information you're providing to the client. The idea of a co-ownership information sheet or something might make life a little easier. And some clients don't read a thing, Mayumi. You're quite right. And therefore, what do we do? There is a limit, isn't there? There's a limit. I want clients to confirm when I've sent documents to the clients that they've read the documentation and understood it. Yeah, well, Zara, there's a firm in South Wales that do exactly that. The report on title goes out, the quiz sheet goes out with the report. The client is expected to complete the quiz sheet and can only do so if they've read the report. Yeah. Yeah, well, I mean, I was talking to someone about reporting on title, and what I said, what I'd like to do, if possible, was to have a virtual house, right? Or ideally, if possible, where the client's house that they're purchasing has had a video recording produced by an estate agent. What I would like is a report on title, which is a standard report on title document, but using artificial intelligence, the recording of the property, enabling the report on title to be sort of connected. So, you're walking around and you're looking at in the video of a private access, for example, discussing the issues relating to that and requiring the client to click when they've seen the pop-up or the bubble about that issue to say, yeah, they've read it and they've understood it and got it. But do you see that? So what I'm trying to do is devise a system that takes us away from the 60-page report on title that the client doesn't read and look at another way of transmitting information. And I think, the idea of a walkthrough of the property with a top-up, with a pop-up or with banners saying you need to be aware of this, you need to be aware of that, or whatever. That's the point, Zara, and more engaging. Yeah. And it is, Megan, I agree. It is a nightmare, isn't it? Because, there's so much information and it is hard work. And the report on title is not a sort of readable document, is it? It's not, and 60 pages, how long is it going to take you to read that? And are you really going to digest each and every bit of it? Well, that's the idea, Dorothy. So, and the point, Dorothy, what I want is that the client clicks to say they've read that and they understand it. So that and you keep a copy of that. So if the client says in 3 years' time, I didn't know about that, you didn't tell me about that, you say, well, hang on a minute, there's the recording, there's the pop-up banner, and you clicked it to say read and understood. Well, yeah, Zara, again, what you could do, and again, I've talked to a company about this, is you have it, or you have, every issue, every pop-up banner or every pop-up is pre-recorded and just goes in there. Are you with me? And I mean, you can get AI that can transmit a report on title into that sort of framework and then away you go. But the thing I like about it is the fact that the client clicks to say, hey, I've got it. Yeah. Or I'll tell you what, Zara, you can even get these days, you can even get AI that will talk it. Yeah. Yeah, exactly. But I think the idea of recording where it pops up and the client clicks, it means that, you know, the client's got nowhere to go. Whereas if it's sent out to the client and you ask the client to read it and confirm it's understood, you know, again, there's a day, well, yeah, I just said I understood it because I had 60 pages of notes. Whereas if it's on a screen, you have a virtual walkthrough and you ping, you know, you click, you know, it's far harder to say, well, yeah, I didn't understand that or I didn't get it. Okay, interesting. Next things, SDLT and advice relating to SDLT. And yeah, Zara, you are realistic. You know, again, it's so difficult, isn't it? Right. So SDLT issues. Do you tell clients that SDLT may be complex and it may be necessary to seek specialist advice? Number one. Number two, do you steer away from specialist advice and give advice relating to SDLT? And the next thing with regard to SDLT, and I think I mentioned this to you before, if you're acting on a new build, right, and the client is paying extra for tiles, special tiles to go into the kitchen, and is paying the builder to build a larger utility room, right? Do you pay SDLT on the cost of the tiles and the cost of the construction work for the enlarged utility area? Dorothy, is that compass that you're using for SDLT? And how are you finding them? Yeah, how are you finding it? Yeah, and Carol, we can seek specialist advice on SDLT. The point is the client needs to be aware of it. I've seen Compass in action, Dorothy, and I was quite impressed, to be honest with you. The other entity that I've seen and used for SDLT issues is a guy called Paul Clark. I don't know if you know Paul, do you? But I think Paul hasn't been well. So I don't know if he's still giving advice to firms. Yeah, okay. So sort of undecided, can we say at the moment, Dorothy? The jury's still out. Yeah, interesting. But again, with the so going back to that, yeah, I think he is. But someone said he was poorly. I don't know, but I like Paul. I thought he was really good on this issue, though. Given what I've said, right? Do you think SDLT would be payable on tiles? And he has doing some stuff for MBL, isn't he? But do you think that SDLT would be payable on the tiles and the cost of construction of the extension to the utility area? Is the point. The firm that consulted me about this said SDLT isn't payable. And I'm saying, why? Because surely the trigger for SDLT is completion of the purchase. And if the tiling and if the extension to the utility area is undertaken before completion, then the tiles and the construction work is a fixture, it's not a fitting. An SDLT should be payable. Lucy, really? Right, okay. Yeah. Well, that was the point here, Dorothy. That was the point. Yeah, Leah. Right. Sean Randall, don't know. Right, he's great. Okay, that's a really good tip. Thank you very much for that, Leah. That's really useful. And again, you know, the whole idea of the forum, if you're using people, etc., and it's worth knowing about who you're using because we can share, you know. So thanks for that. That's great. Paul Reynolds, yeah, I've heard of that. Thank you, Dorothy. That's a good point. I'll make a note of that as well. We share that. Yeah, okay. Thanks, Zara. Yeah, I know shared ownership in SDLT can be a nightmare, can't it? Okay, so on the issue of SDLT and giving advice then, it seems to me that we're all quite comfortable with seeking specialist advice. Do you explain to clients when you're onboarding the client the basic position with regard to SDLT? And do you have a stab at determining what the... Thanks for that, Zara. Again, I'll make a note. Do you have a stab at determining what the SDLT liability will be, but then say it might be necessary to get specialist advice? Is that how you operate on it? Interested. And again, what I always say to practitioners is where... Yeah, essentially the same, Sue. Thanks for that. Yeah, forgot about that. What I always say to clients with regard to SDLT is, look, you've got to be upfront with us with regard to information that you have that could have SDLT implications, first-time buyer issues, linked transactions issues, etc. Yeah, that's right. Yeah, okay. And do you advise Hannah, about the surcharges and reliefs that could be available? Just generally their availability, not whether they apply and the implications of application, if you get what I'm saying. Yeah, okay. And again, advising clients of the fact that an SDLT return is submitted on the basis of information transmitted to you by the client. And again, anyone encounter any issues with regard to SDLT apportionments with regard to fixtures, fittings and contents? Just going on from the point I made a little earlier. Anyone had any issues relating to that? Again, interesting. Or I'm interested. Anyone had HMRC come and have a look at a file or undertaken an investigation with regard to a transaction? I just seem to think that HMRC are so under-resourced, they can't really do anything. And I can't remember a firm telling me about having had a visit or a request with regard to a file. Because if HMRC suspect fraud, they can go back indefinitely, can't they, from memory? Again, anyone else, any other covers, any other issues relating to that? Just waiting for seeing. Yeah, I phoned once for shit. Really, Zara? All right, that's really helpful, isn't it? Yeah, it is good practice if it's second properties, etc. Just okay, yeah. I won't, Sue. Keep secret about that one. Yeah. And you, Megan. Yeah, we'll keep that under our hats, eh? Okay. Right, so let's just have a look then. I'll keep you posted about the Land Registry webinar on restrictions. That's going to be interesting. So if anyone's got any burning issues, let me know, and I'll make sure that we cover those off in that webinar. Anyone got any topics for next time? What I was going to suggest that we have a look at, again, I am still encountering the majority of firms that aren't touching BSA-related work. Why? We need to have a look at that. And because not many firms are doing BSA work, are firms that are doing it able to charge premiums? Airbnb and yeah, happy to do that. Great topic, Megan. Love that one. We'll do that. Airbnb letting is one of my favorites. I did loads of research. Fire risk assessments, we'll have a look at that. Luke, hi Luke, by the way. Yeah, great. Happy to deal with that. Talk about that next time.
Ian, can I just,
yes,
interject? I know that on one of your webinars, we were speaking about the proposed, maybe, draft exchange protocol.
Yes.
I was at a conference and here in Cardiff, and I was surprised at the number of lawyers that when the presenter said, if you do a release, etc., when you come to exchange, do you just put it down as a Formula B?
Mm-hmm.
And the amount of people that said, well, yeah, we just,
yeah, it's not, is it?
But it's not. It's a C, no. And it's exactly. Just so. I don't know whether exchange protocol is a topic.
Yeah, happy to do that. That'd be great. Yeah. Right. So I'm just making a note. Dorothy, no, we can't say management agent fees will be coming for us. I'll check that for you, and I'll make a note of that. But yes, we'll talk about that, Sue. So we'll talk about the code for exchange and release, etc. So happy to do that. I'll make a note of it. And I think it's 2 o'clock, isn't it? Right, so on that happy note, shall we finish at that? Thanks very much, everyone. I've really enjoyed it. It's been lovely to hear from you all. Stay safe. I'll keep you posted about the Land Registry webinar. Property Law UK, anyone interested in finding out more about that? We're having a big push for subscriptions, etc. Keep you informed. And the other thing that we're talking about doing is creating a sort of a group, a solicitors conveyancers group, whereby we provide Property Law UK, we provide webinars and things as part of the group. I'll talk about that next time we get together. But thanks, everyone. See you next time. Any issues, let me know. Lovely to talk to you. Lovely to see you. Speak soon. Take care. Stay safe. Thanks, everyone. Bye-bye. Bye-bye.